You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome to People, Places, Planet. I'm your host, Sarah Backer. On this week's episode, we turn to the U.S. Supreme Court that is deciding now whether to overturn the Chevron doctrine. As a reminder, Chevron refers to the long-standing framework stipulating that judges should defer to agency interpretations of ambiguities in the laws they implement, so long as those interpretations are reasonable. The court will soon rule on the future of Chevron in a pair of fisheries cases, Loper Bright versus Raimondo, and Relentless versus Department of Commerce. Eli staff attorney Jared Page joins me today to discuss our newest report, The Supreme Court, Environmental Regulation, and the Regulatory Environment, which looks at the 50-year arc of environmental law and how it is intersected with the court, and also what a no-Chevron world would mean for the future of environmental protection. Welcome, Jared. Great to have you.
Thanks for having me, Sarah.
The report documents the gradual yet marked shift from a widely held societal consensus about the priority of federal environmental regulation. Can you tell us more about what is going on at the Supreme Court?
Yeah, what a great question, Sarah. This report really touches on an important and live topic right now, and that is the United States Supreme Court. And with this report, we really try to sort of outline the 50-year arc of federal environmental protection and how it intersects with the court. And in many ways, Chevron is the central character of this story. And the report really looks at seminal laws, Clean Air Act, Clean Water Act, our major federal environmental protection laws, along with some of the landmark cases that were brought pursuant to those laws to sort of understand where we've been and where we're going. And I just want to take a minute to sort of walk you through the structure of the report to understand what areas of environmental law we hit on and what the story looks like over time. We tell this story really through a few major federal environmental laws. And so part one looks at the Clean Air Act. The way we've structured the report is to sort of take a couple of bookend cases that the Supreme Court has heard. One from 40 years ago or so, and another one from closer to today and a more recent Supreme Court term, and see what's happened. What's the shift been? How's the approach look like from the court related to a couple of these laws? And so part one begins with the Clean Air Act. And so the early case, an example that we look at there, is the Chevron decision itself. Chevron was a unanimous opinion written by Justice John Paul Stevens that actually ultimately deferred to EPA's definition of stationary source. One thing that Justice Stevens did in his opinion, he sort of pointed out that deferring to an agency's interpretation of a law, like the court did for EPA and stationary source in this case, wasn't something new. But the court had been deferring and looking to what agencies had been doing in terms of interpreting statutes for a long time. And the way Justice Stevens describes this in the Chevron opinion is that this approach that he took in announcing the Chevron framework was based on well-settled precedent in the court's past. Just to remind our listeners, Chevron has become an iconic administrative law doctrine over the past 40 years with its sort of familiar two-step. And I think at bottom, it's about the judicial role. And it's about who decides. So like when there is an ambiguity in a law, who decides? Is it the agency or is it a judge? Chevron really has judges looking to see whether an agency's constructions of laws are reasonable. It doesn't ask for a judge to decide for themselves in the first instance what's the best meaning of the law.
Jared, taking a step back, can you remind our listeners what the two-step test is?
You know, if a judge is presented with a case that a federal agency has put forward an interpretation and they said, we have a statute that we're acting pursuant to, we thought the statute was sort of ambiguous, and so we made an interpretation of that ambiguous provision, and here we are getting challenged in court for our interpretation. And so the judge first asks, when it's looking at that interpretation, was the law clear? Was the statute clear? And that's step one. And so if the judge asks, was the statute clear? And the answer is yes, it is clear. Well, then the case is fairly easy. The judge just sort of does what Congress says. But if the statute isn't clear, and if there's ambiguity, or according to the test that's announced in Chevron, whether there's ambiguity or silence, in the law, then a judge looks at the agency interpretation and determines whether they think it's reasonable. And if the agency has put forward a reasonable interpretation of that ambiguous law, then Chevron tells the judge to defer to that reasonable interpretation. It has recognized benefits. Congress really lacks the time and expertise to legislate to the necessary level of detail that you often see in regulatory rulemakings. And, judges are generalists. They have a high caseload, and they're not necessarily substantive experts in Clean Air or Clean Water Act issues, right? And a lot of environmental statutes are complicated and technical. I think the other benefit that Chevron has that folks point to is accountability. So federal judges are appointed to lifetime terms. And folks who work in the agency, both career and political staff, are at least subject to some aspect of the political and electoral process. So there's a bit of an accountability there. Agencies and agency staff are accountable to the electorate. And so if the people don't like a particular direction that the agency is taking it, well, then there's the ballot box. You don't have that same ballot box opportunity for judges. And so we looked at Chevron from the 1980s, and let's fast forward then to another Clean Air Act case, West Virginia versus EPA. And this one was from a couple of terms ago, and it was a sharply divided opinion, unlike the unanimous opinion in Chevron, and it scrapped the Obama-era Clean Power Plan. And in doing so, it announced the major questions doctrine. What's interesting here is that Chevron wasn't mentioned at all in the opinion, despite the fact that this case involved a federal agency, EPA, and the interpretation of a law that they implement, the Clean Air Act. And so folks are still trying to understand and unpack the ways in which Chevron and the major questions doctrine interact, but the court didn't give us any guidance in that particular case about how the two doctrines work together or don't.
Jared, can you just remind our listeners briefly what the major questions doctrine is?
Yeah, absolutely. Good question, Sarah. So the major questions doctrine, it grew out of this case, West Virginia versus EPA. And I think the short answer is we don't know exactly what the full contours of the doctrine are, and courts are still trying to sort of understand what it is. But there's been a couple of things that have emerged from it that guide an analysis under the major question doctrine. One is this an issue of major political and economic significance? Is this a really big thing that the agency is trying to do? And the second factor is whether or not the agency that's taking the action is staying in their traditional lane. In the Clean Power Plan and in the West Virginia case, the court described what EPA was doing as reordering and reorganizing the nation's energy system by having sources shift from higher to lower emitting sources, generation shifting, they called it. And they saw that as not within EPA's traditional lane that it had been regulating in the past 50 years. So when you sort of couple this really big thing that they were doing with something that's not typically what they do, then the court says that should give judges reason to pause and to hesitate and look for clear congressional authorization of that particular action that they're taking. And I think it's also important to note that the major questions doctrine has implications not just for EPA, not just for environmental issues, but for federal agencies across the government. And it's sort of a new tool in the litigator's toolkit, too. And so I think no surprise, but we've seen many challengers quick to pick this up. And it's really emerging as a pretty frequent tool and argument in litigators' toolboxes, and we're seeing it more and more in all sorts of cases. It actually already featured in another one of the Supreme Court's opinions, one from last year on student debt relief, Biden versus Nebraska. And there's some really interesting lower court opinions that are testing, I'd say, the boundaries of the doctrine, and we report on a few of those in the Supreme Court report, too.
That's really helpful, Jared. So we've spoken about the Clean Air Act. And next is the
Clean Water Act, Part 2.
Wonderful.
Here we take the same conceit. We take an earlier case from the 1980s, and we take a more recent case. And so for the early case in this context, we look at Riverside Bayview Homes. Again, another unanimous opinion by the court. And in this case, they were upholding not EPA's interpretation of a law, but the Army Corps' interpretation of the definition of waters of the United States. And this was in the context of a freshwater wetlands case. And Justice White wrote the opinion for this case, and first of all, applied Chevron. And looked at what the Clean Water Act was designed to do. It was designed to keep our nation's water clean. It was to protect the physical, chemical, and biological integrity of the nation's waters. And Justice White looked at the purpose of the law and looked at the ecological benefits that wetlands provide and the role that they play in sort of the larger system of keeping water clean. And one of the other things that Justice White did in this opinion was focus on the fact that these are difficult questions. These are complex and technical questions, and agencies, the Army Corps in this case, have expertise in these particular areas. And so that's sort of one of the reasons why Chevron makes sense, is because agencies have experts in these areas. And so it makes sense for judges who are generalists to maybe defer to what those experts say. And so fast forward now to another more recent case, another Clean Water Act wetlands case. And this is Sackett versus EPA, just from last term. And so here, you may remember, the court sharply curtailed coverage of the Federal Clean Water Act, upending the status quo as it was understood, like under multiple administrations for decades. And I think the interesting thing to note here in this case is instead of putting forward that ecological view that Justice White endorsed in Riverside Bayview, Justice Alito, who authored the majority opinion, took a dictionary-based approach and didn't really look at the purposes of the statute or the role of wetlands in environmental protection, and also didn't mention Chevron either. So again, even though we were looking at an interpretation that an agency was putting forward, Chevron wasn't mentioned at all.
So Jared, you just said that Justice Alito didn't mention Chevron in the Sackett case. I know that the Chevron doctrine has been coming up less and less in the Supreme Court. Can you tell us, is Chevron dead?
That's a funny question, Sarah. I mean, you're right. It has been coming up less and less at the Supreme Court. And even in cases where it arguably might have come up, the justices aren't grappling with it. They're not using it in their legal analysis. And so it really has caused some commentators and legal observers to say, this doctrine just doesn't matter much anymore. And the court hasn't used it to decide a case in several years. But no, Chevron's not dead. Chevron is applied sort of consistently and regularly by lower courts, by circuit courts of appeals, by district courts all over the country. It's very much still alive, but you make a good question because it's maybe not for long. So here's where the main character in our report really sort of comes back around in part 3, because we're looking at a couple of cases in the fisheries context, and those are Loper Bright Enterprises versus Raimondo and Relentless versus Department of Commerce. These are sort of a pair of fisheries cases, but they are, in fact, in the words of petitioners, a perfect vehicle to reconsider Chevron. And the question presented in the case is just that, is whether the justices should overrule Chevron. And there's sort of a subsidiary question lurking here about whether or not they might not overrule it, but simply clarify.
Jared, so what would it mean to clarify Chevron?
Well, it has to do with this silence point that I was mentioning earlier. In the initial decision, Justice Stevens articulates the test as when the law is ambiguous or silent, then it's an opportunity for the agency to come in and craft their interpretation and the judges to defer to that. But the petition actually says silence should never be a reason to either create ambiguity or to defer to an agency. So the justices might take the position that, yes, when you're in the world of an ambiguous law, then you would defer to an agency's reasonable interpretation. But if you're in the world of a silent law, then no, you wouldn't be in the position of deferring to an agency's interpretation. I think what's interesting is that the briefs from the parties and the over 3-hour oral argument in January didn't grapple much at all with this question and the point about whether or not to clarify silence versus overruling the doctrine wholesale. So anything can happen, but I'd maybe be a little surprised to see that be the focus of the court's opinion.
So what was the law silent on in these cases?
This is another interesting question because the parties have argued about whether or not the law was silent or not. And so NOAA Fisheries would argue that the law wasn't silent at all. The law was either clear that it authorized them to do what they did, and I'll talk about the rule here in a minute, or if it wasn't silent, then at the very least it was ambiguous and gave them the opportunity to then craft their rule. This is a rule that involved monitors. One of the things that NOAA Fisheries does, NOAA Fisheries is the National Marine Fisheries Service, is they carry out the nation's fisheries law. They make sure that the nation's fishing stock is conserved appropriately, right? In order to do that, you need to monitor. You need to figure out how much fish are getting captured of what variety where. And so this particular rule required vessel owners and operators to cover some costs associated with having some of those monitors on board their vessels when they were out fishing for Atlantic herring. I think one thing that's interesting about the case, though, is this idea of, boy, we really have onerous costs that we need to bear to continue to go out fishing and comply with government regulations. The petitions don't actually mention a specific economic injury or a specific fishing trip that they went out and had to pay money that they didn't get reimbursed for. So NOAA records actually reveal that 100% of this program's monitoring costs were eventually reimbursed. There's still a sort of open question about, do petitioners have standing to bring this claim? What was the injury involved here? And similar to what I just mentioned a minute ago about this questions of silence, oral argument in January also didn't talk much about this idea of standing and whether or not the court even has jurisdiction to hear this case in the first place. Again, sort of given that, I would doubt that the case will be dismissed on some sort of procedural ground like standing, but again, you sort of never know.
Jared, it seems unlikely that the court will try and clarify the Chevron doctrine. So what's the other option?
Well, there's a couple different options. One option would be to announce an entirely new doctrine that we sort of don't know what it will be yet. But if the court overrules Chevron, that's going to be pretty interesting. And so the next part of our report, actually, part 4, looks at that question of like, well, what if the court got rid of Chevron? Again, we don't know what it'll replace it with, but what does that mean for the people who've relied on it? What does that mean for Congress? What does that mean for federal agencies? What does that mean for judges? And so part 4 really breaks down each one of those constituencies and looks at, what is this going to mean?
Great. So we'll have people take a look at the report, of course, but can you just give us a little bit of a teaser on what you all think it will mean for Congress?
In a no Chevron world, I think for Congress is going to have to speak with intricate precision to achieve its goals, right? I don't think I was super clear on this before, but Chevron doesn't just apply in the environmental context. Chevron is a doctrine that applies across all of federal agencies. So whether we're talking education, healthcare, food safety, securities, you name it. And so Congress will have to be able to legislate in all of these areas without any ambiguity if they want to delegate authority to the agencies in the way that they want. That's if they're thinking about crafting new laws and how do we write them appropriately. But what about the existing laws? Does Congress now need to sort of update laws to eliminate any ambiguity and delineate agency authority with clarity and specificity? It's a real challenge to somehow ensure that agencies have the flexibility to respond to these unanticipated problems in a way that gives the agencies certainty and confidence that what they're doing is what Congress designed and designated. If Congress needs to speak with intricate precision, it's a real challenge because recent Congresses have struggled. They've struggled to build robust bipartisan coalitions that are comparable to the ones that passed the landmark environmental laws of the 70s. Some research suggests that even if Congress was able to spend more time on legislative drafting, the institution just really isn't equipped with the scientific resources and background and knowledge that's needed to legislate in the requisite detail and to legislate to the level of detail that you often find in regulatory rulemakings.
Thanks, Jared. Can you expand a little bit more on what the ruling would mean for federal agencies?
Sure. Agencies are going to have to move forward with the laws they have. Political appointees, career staff that are responsible for the day-to-day operations. It's possible that in order to sort of fly below the major questions radar, they might limit the expansiveness of their rules, whether that's the real expansiveness or even the perceived expansiveness, like breaking down their regulatory actions into smaller pieces that aren't necessarily seen as approaching that significance threshold that we talked about, and maybe avoiding novel approaches, like we talked about staying inside of your lane, even if they are in accordance with a statute's purpose, structure, or legislative history. I think the other thing, and this is responsive to the outcome in Chevron, will be that federal agencies will really thoroughly scrutinize any arguable ambiguity, not just ambiguity, but any arguable ambiguity in the statutory provisions they implement. I think this will happen both in rulemakings and, of course, in court, because they want to figure out where are those potential points of contention. One other thing, though, and that's this idea that Chevron has fallen out of favor. We mentioned this a little bit already. And agencies have actually already started to trend away from relying on Chevron. We looked at a 2013 survey of agency staff. And in that survey, 90% of the staff reported that Chevron played a role in their drafting. So the vast majority of people, this doctrine was integral in terms of how they supported their rulemakings. In contrast, a recent study from the Brookings Institute found that major Biden administration rules that were published, I think around 50 of them, and less than 5% of those expressly cited Chevron as a justification for them. 90% in 2013 found it really important, and now less than 5% of major rulemakings are relying on Chevron.
Thanks, Jared. And so perhaps most importantly, where would this leave federal judges?
Well, great question. I mean, these are the ones who've been applying this framework for the last 40 years. So first and foremost, judges will be left really parsing the opinion very closely in these sets of cases in terms of what did the court say and what direction do we now have in terms of reviewing agency interpretations. But in a no Chevron world, each judge potentially will take on a more leading role. Instead of double checking an agency's legal work to make sure it's reasonable, judges might be in the position of reviewing it anew. And what's interesting to note, because the Supreme Court has looked at and looked to agency expertise and experience to help it answer questions of statutory interpretation dating back nearly to the founding. And throughout the 19th and throughout the 20th centuries, courts have acknowledged the importance of listening to the experts who implement these complex statutory schemes. It was that well-settled history that Justice Stevens actually cited when he articulated the Chevron test in the Chevron case itself. And I think one of the other things to note is when judges take on a leading role and they're reviewing statutes anew, judges don't always necessarily agree on what the best interpretation of a law is, which sort of sets up the idea that you might have one federal district court judge in one area of the country interpreting a law differently than a federal district court judge in another part of the country. And this presents the opportunity for a circuit split, and not just on one question and not just in one area of law, but sort of across agencies, across issues. And I think the challenge here is that the Supreme Court's docket, of course, is discretionary. They only take 60 or 80 cases or so a term, and depending on how many different interpretations by judges pile up, the Supreme Court won't be able to resolve all these inconsistencies and imbalances in federal law. One influential amicus, Thomas Merrill, who's really an expert on the Chevron stuff, I think makes the point well in one of his friend of the court briefs, who says, this situation really has meaningful costs. Reduced uniformity in federal law, more decisions that aren't well informed about highly technical or specialized areas of the law, and decisions that don't cohere well with complicated statutory schemes. And so when we look at what does this mean for all these different constituencies, it's a really daunting question. And we try to help unpack some of those in a more specific context in part 5 of the report, where we do a deep dive into what some of these responses look like after the Sackett decision. And then part 6, we sort of zoom out even further to look not just at water, but broader. What does the future of environmental protection look like in this new era?
Thanks for being on the podcast today, Jared. I feel like I've learned a lot about the Supreme Court, environmental regulation, and the future of the regulatory environment.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.